Hello and welcome to Ellison Legals in case you missed it. So we are now in July and we will go over June's posts. As usual, just a couple of disclosures. Ellison Legal has limited liability under a scheme approved by the Professional Standards legislation, and this video is not intended to give you legal advice, so please don't take it as legal advice. So if you do need legal advice, please go see your legal practitioner to get some advice that is tailored to your specific situation. So in terms of what we looked at in June, it was wills and estates. So we've gone back to basics with that. We had 4 posts. So let's get started. So with the first post was just about general administration. So what work it is that we do and what we can help you with general administration. So that's of deceased estates. So there is the general administration. That's if you don't need to go to a court and get a court order, a grant. There's also something called a grant of probate, and there's also a grant of letters of administration. So basically the difference between those three, where you don't need a court order, is if there's, say, assets that are quite nominal. Say it's a bank account of, I don't know, $5,000. The bank may not ask for a grant of probate. It may be just title. It might be you and your spouse, and in the sad event, if your spouse has passed, predeceased you, and it's a joint ownership in a home, not tenants in common. So this comes back to my property posts. Joint ownership, it goes directly across, so you don't need a grant for something like that. So there's certain situations where you don't need a grant. Where you do need a grant is your grant of probate and grant of letters of administration. With a grant of probate, so that's where you have a will. Doesn't appear to be any issues with it. It appears to be valid. There's you've nominated a person to be your executor. You've nominated who your beneficiaries are. You apply for a grant of probate. With a grant of letters of administration, you could have a will, or you may not have a will. So if you don't have a will, straight up grant of letters of administration. But if you do have a will and there's a problem with it, so say, for example, you've said, this is my last will and testament and I leave X to person A, and that's it. You haven't said who you want to do all this for you. You haven't nominated an executor. That's an example. That's going to be a grant of letters of administration with the will annexed. So those are the 3 types of estate administration. The second post, we were alerting you to wills, who has one, who doesn't in Australia. So I think about 3 years ago it was around the 47% mark, something like that. It's now 50%, it's gone up, great, fantastic, but let's get that up a little bit more. It's going to be a really sad event if someone passes, they haven't got a will, you haven't had that opportunity to say what you want to happen to your assets, you haven't nominated a guardian for your children, have your last say. It's really important to get a will done. So 1 out of 2 people have one, a valid will. Come on, the other 2, the second person out of the 2, go out and get yourself a will. I would really encourage you to get legal advice. Preparing wills isn't as simple as they once were. There's so much to consider, and I often have clients saying to me, it's a basic will, and I do try to keep it as basic as I can, but when I go through all the possibilities with them, that the comment more often than not is, wow, I didn't realise there's so much involved. So please do try to get some legal advice on that and go out and get yourself a will. The third post was if someone has passed, so now you're dealing with a deceased estate and you can't find the will. You may not know if there was a will. You may know that there was a will, but it's not anywhere to be found. So what to do then? it's important that certain inquiries are made. So you first need to establish, was there a will? If there was, does it invalidate prior wills? Was it destroyed? Was it destroyed on purpose? Was it ripped up? Was it destroyed in a fire? Did you know what the deceased's wishes were? And if you do find it, or if you find a copy of it, has it been signed correctly? That is, for example, in front of 2 independent witnesses. So things like that could be a way of, when you go in for your grant of letters of administration, to try to present to the court a will not in its original form. If you can't find the original, but you found, say, a copy of it. So different things like that. So if there was a will, if you know that there was a will, can't find it, there's different things that can be done for something like that. The last post was about challenging an estate. So sometimes a loved one passes away, and then you find out how the will is to be distributed, what they've said, what they want to happen. Some people may find that disappointing. That's a reason that what we call an eligible person may want to challenge an estate. They may not feel that they have received a sufficient benefit and they're in need, for example. But there are also situations where you may feel that your loved one was coerced into making a new will that basically cut everyone out, say like cut all family out, or undue influence, or even things like fraud. So those are reasons why people would want to make a claim or challenge an estate. So that's something else to think about if a loved one has passed. So those are the 4 posts. I'm going to put that down. We're back here in isolation, so I hope you are all keeping well, staying safe, stay home, do all the right things, and hopefully we'll get through this. So I will leave that there and see you next month in August, going over this month's post, going over July's posts. So until then, take care.